Good afternoon, everybody. I'm Kerry Edwards from the Chartered Institute of Fundraising, and I'd like to welcome you all to our webinar, How to Use the New Code of Fundraising Practice. Now, I know you'll all be aware that the new code was launched in late April, and we're now living through a 6-month grace period where charities can review the new code and make adjustments to their fundraising before it comes fully into force on the 1st of November. This is a pivotal moment in fundraising. The code has been significantly streamlined and now focuses on overarching principles rather than prescriptive rules. It introduces us to new ways of thinking about fundraising practice, which is why it's essential for us to use this 6-month grace period fully to understand how these changes will impact our work. And that's why I'm delighted to be joined today by Hannah Lyons, partner in the Charity and Social Enterprise Department at Bates Wells, who will give us a brief overview of key changes to the code and answer your questions about applying it to day-to-day practice. But before I hand over to Hannah, I have a few housekeeping announcements. First of all, as there are over 500 of us on this webinar, please can you submit all your questions through the Q&A tab at the bottom of your screen and not in the chat. That's the Q&A tab at the bottom. If you do have any technical questions or any technical issues, feel free to post those in the chat and one of the team will be in touch. And finally, this webinar is being recorded so that we can make it available to you and your colleagues for continued reference. And now, with the housekeeping done, I'm pleased to hand over to Hannah Lyons. Hannah.
Thank you so much, Kerry. As Kerry said, I'm Hannah Lyons. I'm a lawyer at Bates Wells, and I specialise in advising charities and other organisations on fundraising law and regulation. And I'm very excited that the new code is finally here. We have spent many hours feeding into the various consultations, as I know the CIOF has, and many of you will have done. And I think some of you may have attended the helpful seminar run by the CIOF and Connor Gibson from the fundraising regulator a few weeks ago. I'll try not to repeat too much of that in this session, and I instead want to focus on how charities can use and interpret the new code, as well as give some practical tips on how your organisation can be getting ready ahead of it coming into force on the 1st of November. So this is what we will be covering today. I will start by giving some brief background to how we arrived at the new code and some timelines for implementation. I then might slightly unusually focus on what hasn't changed. There's a lot that's staying the same, which should hopefully provide some comfort to you. But we will, of course, also be covering what is changing, both in terms of content of the code and the approach it now takes. We'll then look at how to practically use and navigate the new code and the new code support guides that have been drafted in conjunction with it. I want to focus on how the new code represents a shift in the regulatory approach taken by the fundraising regulator, and then provide some practical examples of how to interpret and comply with certain sections in light of that change. And then finally, I'll leave you with some top tips for how your organizations can be getting ready for the new code in the current transitional period. I'm going to try and leave a good amount of time for questions at the end. So as Kerry said, please do make sure you're putting those in the Q&A and we'll come to those at the end. So let's jump in. There's been a 3-year review process of the code starting in 2022. We've had 2 rounds of consultation, one on proposals for what the new code might contain, and then a more detailed consultation last year on the revised draft itself. The fundraising regulator heard from over 200 organisations as part of that process, and I know lots of you including the CIOF, spent lots of time feeding back, which is much appreciated. And I think the fundraising regulator has taken some of that feedback on board in the final draft. So the final draft was published in April of this year, and it will come into force on the 1st of November 2025. As we've said, there'll be a 6-month implementation period to get ready for it. In the meantime, the current code remains in force. So if there's any complaint or investigation that the fundraising regulator launches in that period, it will adjudicate using the existing code rather than the new one. So what hasn't changed in the new code? I thought it'd be helpful to start with what is actually staying the same. So the code is structured in the same way as it is now. So part 1 includes standards that apply to all fundraising, such as fundraising behaviours, responsibilities of those who govern charities, and processing donations. Part 2 still covers the standards which apply to working with others, so that includes volunteers, children and those in vulnerable circumstances, and fundraising partners such as professional fundraisers and corporate partners. And Part 3 covers standards that apply to specific fundraising methods such as online platforms, events, and legacies, among others. The core principles of the code are also staying the same. So all fundraising must still be legal. Fundraising must meet the requirements of the law. That's pretty obvious. It must be open. Fundraisers must be clear about their processes and be willing to explain them when necessary. Fundraising must be honest. So fundraisers must act with integrity and must not mislead the public. And all fundraising must, of course, be respectful. Fundraisers must respect the people and places they interact with. So I think if your organisation is mindful of these core principles in its fundraising, then it's going to put you in very good stead for complying with the new code. Most of the content is quite similar to the existing code. There are some new sections and things that have been cut down or moved around in places, but it's not fundamentally different from the current code. And the status of the code remains the same. So it's not legally binding. It's a core part of, it's a voluntary code that forms part of the self-regulatory regime for fundraising. And if someone makes a complaint or if there's negative press, the fundraising regulator will investigate in the same way and make recommendations or publish its findings. And it can do this, of course, if your organisation is registered with it or not. And it still applies to the same range of people. So it applies to charities, social enterprises, and CICs, that's community interest companies that carry out fundraising. It also applies to professional fundraisers, commercial participators, fundraising platforms, volunteers, and third-party suppliers and agencies. So you'll all want to know what has changed. And there are, of course, quite a lot of changes that we do need to be aware of. So it is 45% shorter than the current code, although it is still 93 pages, so still pretty hefty. And the fundraising regulator has consolidated, merged, and streamlined a lot of the code provisions so that it's easier to read and digest. They have also stripped out code sections which repeated legislation or which dealt with topics where they are not the league regulator. So rules relating to data protection provisions, gift aid, and lotteries are good examples of that. Instead, the new code signposts relevant legislation, codes set by other regulators, and sector guidance from the fundraising regulator, COF, Charity Commission, ICO, HMRC, and others. This certainly makes the code more manageable to read on the face of it, but it does mean that users will have to look at other guidance and rules, so it's no longer all in one place. The biggest change, and one that there was a lot of debate around during the consultation period, is the move to a principles-based approach to regulation. And this essentially means that rather than including lots of detail about how the rules should apply, there are broader rules which can be applied to a wider range of scenarios. Lots of other regulators take this approach, and the fundraising regulator has set out the advantages it sees in adopting this approach. So firstly, it sees it as less prescriptive. It removes the need to list every practice that is or isn't allowed in relation to your fundraising activity. It's more flexible. It allows rules to be applied in a wider range of contexts, so each specific fundraising approach does not need its own set of rules. It sees it as being proportionate, so it allows fundraisers to consider appropriate action to be taken based on the size and nature of their fundraising activities. That will very much depend on the nature of your organisation. And it also helps to future-proof the code. The fundraising regulator has said that it allows fundraisers to apply the principles to a range of contexts without having to wait for specific advice about new approaches. So it's essentially creating a framework that can be applied to a range of different fundraising activities and sizes and types of organisation. During the consultation period, there was quite a lot of debate and discussion about this and about whether the code should have different rules for different sized organisations or includes specific sections on new areas of innovative fundraising, such as AI or crypto donations. The fundraising regulator decided against this, presumably because the code would very quickly become out of date if it tried to cover everything in detail, and that it would be too difficult to try and devise a code that applied to every different type of organisation. So whilst I think there are definitely advantages to the principles-based approach, it does in some cases make it harder for organisations to know exactly what they need to do to comply in a particular case. And I'll talk about this shift in regulatory focus and what this means in practice for you a bit later in the session. So focusing on some specific changes in the code, there are some sections that have been added. There's a new rule on protecting fundraisers. I think the fundraising regulator has listened to feedback about the adequate protection of fundraisers as well as the public. And so there is now a new requirement to protect fundraisers from harm and harassment whilst fundraising. This may include having processes for fundraisers to report any issues that arise, for example, to their line managers or through a more formal whistleblowing policy, and taking reasonable steps to deal with any issues that are reported by them. There is also, interestingly, a new rule on engaging constructively with the fundraising regulator in the event that it investigates a breach of the code. In my experience, most organisations do engage with it well, but it will now be a breach if you fail to do so. And the code also says that you must make sure any fundraising partners also engage constructively if the regulator has any questions or investigates, which I think might be a bit trickier to achieve. And there are also new sections on convenience giving and unstaffed collections. These cover things such as static collections, as well as tap to donate and other automated giving methods, plus kind of top up donations. For example, you might have seen that at the supermarket when you can top up your bill and that will go to a charity. And in summary, these new rules require there to be clear and accurate information about the collection, so including names and charity numbers of the charities that are benefiting, plus details of any processing fees or payments to third-party fundraisers that may be running the collection on your behalf. Some code sections have also been quite heavily amended. The provisions on paying fundraisers have been stripped right back, so the code no longer sets out commission-based payment rules and instead includes a very non-prescriptive rule about giving appropriate consideration to the approach to paying fundraisers and considering whether this fits with your organization's values. I think there's been quite a lot of discussion around this point, but the fundraising regulator recognizes that it's a complex area with lots of different options and considerations, and that employment law advice is probably needed on specific scenarios. There's also a new standalone section on fundraising platforms. So that's aimed at those that run fundraising platforms online. And I think that is really helpful in ensuring that platforms are transparent about fees, etc. And finally, data protection provisions have disappeared. They currently sit in section 1 of the code. They've all been stripped out, and instead there is signposting to ICO guidance. But there are some specific rules on direct marketing in section 8, so it's worth looking out for those. I'm unsure if those new rules will be updated to take account of the extension of the soft opt-in exemption to charities, which is hopefully coming into force quite soon under the Data Use and Access Bill. So yeah, not sure if the fundraising regulator will make some updates in relation to that, or they may issue some accompanying guidance instead. So moving on to how do we actually navigate the code and its new format in practice? I've got some examples on the next slide, so don't worry, it will all become clear. But the code section, so the code rules themselves are set out in bold text within the new code. And at the top of each section, there is a heading which explains who the rule applies to. So whether that's a fundraising organisation, so a charity, the charity's governing body, a third-party fundraiser, etc. So it's always good to check at the top of each section who it's actually applying to so that you can understand the context. Some rules have bullet point lists of examples which set out actions which are never allowed in relation to that particular rule, actions that are always required, or examples of ways in which that rule could be met. And the regulator has stressed that these are not intended to be complete lists. If they investigate your fundraising, they may ask you to explain how you met the expectations listed or how you used a different approach to meet that rule. There's also some wording in plain text, so explanatory notes, which explain how a rule may be applied, or it flags other important legal or regulatory requirements that apply. And I think the intention is for these explanatory notes to be updated and changed more easily. So, for example, if there's a change in law and regulation, they can explain that without having to consult fully on changes to the code sections themselves, which will hopefully make the code a bit more agile. There's also some text boxes, you may have seen those in the new code, which explain and signpost to relevant legislation in each section, as well as providing links to guidance from other regulators and sector bodies, including the Chartered Institute of Fundraising, and they are down the side of the new code. And then finally, at the end of the code, there is a revised glossary of key terms, which is also quite helpful and worth having a look at. So here is an example of the revised code and some code sections. So you'll see at the very top there that it says that in this section, you, so where it uses you, applies to the charitable institution or third-party fundraiser, so you know who it's aimed at. You've got the wording in bold there, which denote the actual code sections, and then you'll see the wording in plain text, so not bold, provides the explanatory notes about how each of those code sections should be applied. You'll also see some bullet point lists, so 1.1.2 there about taking reasonable steps to make sure that your fundraising is carried out in a way that reflects positively on fundraising in general. They've set out some indicative examples there of how you might show that you are meeting that code standard. And then you've got a link to additional fundraising regulator guidance. Sorry, that's been cut off at the bottom there, but at the very bottom of that page, there is a hyperlink to where you can find out more information on guidance on general behaviour. This is another example. So this section relates to how you might treat donors fairly as part of your fundraising. And you'll see at the bottom there a text box which explains and signposts to relevant information and legislation which applies to these code sections. In this case, it's telling us about how the Equality Act might apply. So hopefully that's helpful in just visualizing and seeing how the code should be read and interpreted in practice. The fundraising regulator has also published 3 new code support guides, which are aimed at supporting organisations to comply with the new code. They have stressed that this is not legal advice and instead is advisory and non-exhaustive and should be used in conjunction with other guidance. I think they are going to be issuing more code support guides, but the first 3 focus on documenting fundraising decisions, due diligence and fundraising, and monitoring fundraising partners. I won't go into loads of detail into all of them, but the first one is really important in terms of getting to grips with the new principles-based approach. This guide focuses on the governance of fundraising within an organisation and sets out how decisions about fundraising activities should be made and recorded. It also deals with managing any conflicts of interest that may arise, accepting, refusing, and returning donations, and dealing with complaints and concerns. That one also actually, I should mention, includes some advice around complaints handling and kind of lessons learned. So making sure that you're not only kind of recording your complaints, but also assessing any themes and addressing how you might prevent those situations and complaints occurring again in the future. We've also got a new guide on due diligence, and that includes guidance on risk management and when and how you should carry out due diligence on donors and fundraising partners. That also includes some quite useful links to other guidance from the CIOF and the Charity Commission on how you might approach due diligence. I know that is a perennial issue and question for charities on how much they should do. And the Charity Commission actually has quite a helpful toolkit on due diligence on donors, so worth having a look at that. I think that is linked to within the guidance. And then the final code support guide that we have at the moment relates to monitoring your fundraising partners. So that would include fundraising agencies that might be raising money on your behalf, or corporate partners that might be undertaking fundraising promotions for you. So a lot of this guidance reflects the fundraising regulator's recent market inquiry report into face-to-face fundraising. Some of you may have seen that. That was published last year. There were quite a lot of investigations and press reports around face-to-face fundraising, so that the regulator decided to launch a specific inquiry in relation to it. And there's various findings and recommendations in its market inquiry report, some of which have kind of made its way into this guidance. And it essentially sets out what you need to do in terms of having robust agreements in place with your fundraising partners, particularly around subcontracting. So that was one of the key elements it looked at as part of the market inquiry, is whether charities had sufficient oversight of, everyone that's maybe working for it in a fundraising chain of fundraising agencies. So making sure that your agreements talk about subcontracting, whether it's allowed, and if so, kind of what are the parameters set around that, and what oversight will your charity have of people working on your campaigns within that subcontracting chain. The guidance also has some helpful top tips on approaches to monitoring your fundraising partners, which I think is also a tricky issue, and around training your fundraising partners as well, to make sure that kind of the values of your charity are being addressed by others who are fundraising on your behalf. And again, it also contains a section on complaints handling and how that should be managed between you and your fundraising partner. So I appreciate that we've talked a lot about what's in the new code, but I wanted to kind of draw some of that together and talk about the shift in regulatory approach, which I mentioned at the beginning of the session. And I think that is probably the biggest change with the new code, rather than the content itself. The move to a principles-based code means that there will be a greater need for organisations to interpret the code and assess how the rules apply to their particular organisation and fundraising activity. And you'll need to be taking a step back and assessing what is appropriate, reasonable and proportionate in the circumstances, because the code no longer kind of very prescriptively sets out what is expected. And this will very much depend on the size of your organisation, whether you're a small, medium or large organisation, the types of fundraising you do, and the risk profile of that particular activity. You'll also need to be able to demonstrate why you think your fundraising approach is in line with the code. So we saw that with the new code support guidance on this topic. You'll need to be able to justify the decisions that have been made and be able to show the fundraising regulator records of that decision making if they ever investigate your practices. And this is much more like the way that the Charity Commission currently regulates. So it's not new, but it is something that the fundraising regulator, I think, is shifting towards. As I mentioned, there's definitely more of a focus on kind of the wider governance of fundraising and making sure that's embedded at the right levels of your organisation, and making sure that decisions are being made by the right people, and that those decisions are then being appropriately documented. So that might be, for example, in meeting minutes, so board meeting or committee meeting minutes about particular fundraising initiatives. Recording that in your policy, so making sure you've got a clear framework for how you're going to apply the code and relevant legislation in relation to your fundraising practices, and also making sure that you've got appropriate procedures and risk assessments written down so that you can show all of that to the fundraising regulator if they ever come knocking. Given that the code is less prescriptive, I think you will need to have reference to other guidance and code. So, for example, I mentioned that all the data protection content has been, or most of it's been stripped out. So you'll need to go and look at ICO guidance in relation to direct marketing and fundraising communications, for example. Similarly, lots of the gift aid content has been stripped out, so you'll need to look at HMRC rules. So I think it will mean a bit more signposting and jumping around to other guidance. I wanted to put some of those kind of more abstract concepts into practice, and I've now got 2 examples of how I would approach interpreting the code in this new regulatory context with the new principles-based approach. So I've set out rule 2.2.2 here. The fundraising regulator actually uses this as an example in the introductory section to the code. So I'll read out the code section. It says, you must carry out appropriate due diligence proportionate to the size and nature of the donation on the potential donor before accepting a donation. So what is appropriate and or proportionate in the circumstances? That can be quite difficult to assess. But there's a number of questions I think you need to ask yourself so that you can build kind of an appropriate framework for complying with this code section. So firstly, it will very much depend on the size of your organisation, as well as the size and nature of the donation in relation to your fundraising activity. So if you're a smaller charity that tends to get small cash donations, the level of due diligence you'd be expected to carry out under this code section is much less than a larger charity that receives large donations in various formats. So, if you're receiving cash donations, that's going to be much lower risk than if you're receiving donations that come in unusual or potentially risky forms, such as gifts of shares or cryptocurrency. You'll also need to be thinking about the particular reputational risks surrounding the donor. Again, that's probably going to be need to be more enhanced due diligence for larger charities where there might be some press around that donation, etc. And do you have an internal policy that you can follow to help guide and record some of your decision making around how you will approach due diligence and why you think it's proportionate and appropriate for your organisation? So lots of charities will have a due diligence policy or accepting and refusing donation policy, which sets out how they will approach donations and due diligence on those. So, what thresholds will trigger the need for certain additional due diligence, etc. So I think if you can document all of that, if you haven't got a policy, it might be worth putting one together, even if you're quite a small organisation, just having quite a simple policy. If you record all of that and set out your reasoning for why you think that's appropriate, I think it's going to be quite hard for the regulator to challenge that and say that you would be in breach of that code section. And I'd also recommend obviously looking at the code support guides on due diligence and sector guidance from the CAOF and Charity Commission to kind of help draft that policy. So it's essentially about assessing the risk in relation to a donation and establishing a workable framework for due diligence within the organisation. This is the second example that I pulled out that I thought was quite an interesting one. So it relates to Rule 6.3 around monitoring that fundraisers are keeping to the code. And the first limb is that you must make all reasonable efforts to make sure that any third-party fundraisers you work with keep to the code. And you must make all reasonable efforts to monitor whether third-party fundraisers are keeping to the agreement you have with them. So again, we need to think about what is actually reasonable in the circumstances for your organisation. And that will very much depend on the nature of the relationship and your engagement with that third party. So who actually are they? Are they a face-to-face fundraising agency that might be collecting donations on your behalf? Is it a corporate partner who you are, say, entering into a Charity of the Year arrangement with? Or it could be an individual consultant who you brought on board to help with your fundraising internally and maybe help with fundraising strategy, etc. So first you need to kind of think about what's actually the nature of the relationship and what's the risk profile here. Hopefully you've got an agreement in place with them. You should do in most cases. So you need to think about what are the actual obligations under the contract. What do we need to be holding them to account for? And then you need to be thinking about what types of monitoring may be appropriate in the circumstances. And that will, again, will very much depend on what's happening and what they're doing for you and the level of risk involved. Types of monitoring that we typically see, so for face-to-face fundraising, it might be some mystery shopping. shadowing of fundraisers, conducting site visits to agencies, holding monthly meetings with them to assess any issues that are cropping up or any kind of complaints or themes that you're seeing there. And again, checking compliance against the contract. Are they actually meeting the standards required? And gaining feedback from donors and staff, or doing some media monitoring. And again, if it's a corporate partner, that all of that probably isn't appropriate, but you might be doing some regular meetings with them. You might be checking that all the content they're putting out, any social media posts, any use of your name and logo, etc., is appropriate. So very much depend on what they're doing for you. But the code support guide on monitoring will be helpful, I think, when assessing this code rule. But again, I think it's about being able to demonstrate to the regulator that you are on top of all of this. You do have appropriate frameworks in place, and even if complaints are raised, complaints will always come up. You can fall back on the fact that you did have a robust process in place for monitoring and making sure that your partners are keeping to the code and your agreements as far as possible. So I am nearly at the end, actually, so we'll have plenty of time for questions, which is good. But I just wanted to finish up with some top tips on how you can prepare for the new code in this transitional period. So firstly, and fairly obviously, those who are responsible for fundraising should be familiarizing themselves with the new code. I mean, it is, as I said, 93 pages, so I would recommend starting reading section 1, which applies to all fundraising, so the core rules that apply to all your activity. You can then identify the sections that are relevant to the fundraising that your organization does and focus on understanding those. So, for example, if you regularly run events, you should be looking at the events section in part 3. If you do a lot of legacy fundraising, you want to look at the legacy section. And if you do regularly engage with fundraising partners, then focusing on part 2 will be really important. And if you're a large charity that does lots of different types of fundraising, then unfortunately you might need to sit down and read the whole thing. If there's a few of you in the team or within a department which is focusing on this, then you could maybe divide up different sections and have a workshop to discuss the impact on your organization's activity, so that there might be ways of making it a slightly easier task. Secondly, I think it's really important to raise awareness about the new code within the organization. Fundraising and compliance teams will, of course, hopefully be aware of it, but it may also be necessary to ensure that other key stakeholders are also brought up to speed. So that would include your board of trustees, maybe people in your finance team, and also third-party fundraisers that you might be working with. And I think this is particularly important due to the new focus on ensuring that fundraising is appropriately embedded in the governance of the organization. So a board briefing or even some short training for the trustees might be helpful ahead of the 1st of November. And depending on the size of your organization, it would also probably be sensible to carry out some specific training for fundraising teams and relevant external suppliers on the new code, particularly focusing on the areas that are most relevant to you. Even if the changes aren't going to have a big impact on your organization's fundraising, it's probably a good juncture to have a refresher. I think, as was the case with GDPR, there weren't actually that many changes in relation to existing legislation, but the ICO used it as kind of a bit of a juncture to try and get the level of compliance up generally, and I sense that might be the same with the new code, that even though quite a lot of it's not changing, it is a time where I think the fundraising regulator will expect people to be looking at it carefully and making sure that their existing processes meet all the code standards, whether they're new or not. And just a few more top tips on this slide. Again, some of these are probably pretty obvious, but I would recommend checking your fundraising policies and procedures, whether that might be your complaints policies, donor due diligence policies, accepting and refusing donations policies, etc., and updating them so that they align with the new code. That may just mean updating code references. So if your existing policies or training materials reference the current or old code, then you'll need to update those. But you might also take it as an opportunity to make some wider or more in-depth changes to ensure compliance with the code and relevant legislation. And if you undertake fundraising activities with third parties, say, for example, any consultants, corporate partners, fundraising agencies, or other fundraising suppliers, then I definitely recommend looking at the terms of your existing contracts with them and assessing whether they meet code requirements around monitoring and subcontracting in particular, as well as the legal requirements that should already be being met. As I said, the fundraising regulator has had a big focus on this in recent months in terms of contracts with third parties. So it's an important element to get right, I think. And it's also a good opportunity, to check that your contracts comply generally with charity and fundraising law, particularly in relation to professional fundraiser and commercial participation arrangements. And finally, you should consider how your organisation will demonstrate compliance with the new principles-based approach to fundraising regulation. As mentioned, I think this is probably the biggest and change and one of the trickiest things to navigate under the new code. And you'll need to establish a framework for making sure decisions are properly made and documented without that becoming a very burdensome exercise, which slows down your fundraising activity. So I think a bit of a balance to be achieved there. And the way you approach this will obviously depend on the size of the charity. So small charities will not be expected to have the same record keeping as large ones, but I definitely think it's something that everyone should be thinking about ahead of the 1st of November.